Anand Bhushan, if you could join me up here, please.
Hello, everyone.
Good morning, Anand.
Good
Thanks
morning.
for joining us.
Good morning. My pleasure.
We also have Ms. Anita Suresh, who's here. Please join us. And joining us virtually, we have Mr. Nandan Kamath. Nandan, are you there? Great. All right. Well, so again, as I was saying at the beginning, we have a distinguished group of panelists here today to discuss intellectual property rights. This is the 19th annual commemoration.
We have Shastra.
We have Shastra on the line as well.
Yes, sir.
Okay, very
Also,
good.
Satish from Shastra next to us.
Excellent. Thank you for joining us today from Tanjore. So, yeah, we have some students and faculty at Shastra University who are joining us virtually as well. So this is kind of an example of our dynamic programming here at the American Center where we connect virtually. This is an interactive session. This is being streamed on Facebook Live, and I would invite you to submit any questions in the chat box. So again, to my left is Mr. Anand Bhushan. Welcome. He's the head of the Chennai office and a partner at Shardal, Amarchand, Mangaldas and Company Advocates.
And you pronounced that very well.
Okay, thank you. I practiced. To my far left is Ms. Anita Suresh. She's a junior partner at HSB Partners and Advocates. And then again, joining us virtually from Bengaluru, we have Mr. Nandan Kamath, who's the principal lawyer at Law NK and managing trustee at Go Sports Foundations in Bengaluru. So, and this is a very important issue around the world and in particular in the United States. In fact, if you go back to our history, this is something that was important to American values from the beginning of our country. Our very first president, George Washington, signed a patent law back in 1790, more than 200 years ago. And our third president and first Secretary of State, Thomas Jefferson, helped to examine the first patents of our country. So, over the past 200 years, we've seen the importance of intellectual property rights and law in terms of spurring ideas, creation, innovation, and respecting the intellectual property of those creators.
I'm just going to turn that away because I think it's nice.
So the protection of intellectual property rights is important for successful businesses and legal professions, and this contributes to the economies, this contributes to the creators, and we have to remind ourselves that IPR protection
And that's a big lapse in the otherwise glowing India growth story, right? Which is we've largely had a non-IP based growth scenario. What do I mean by that? If you take our technology industries, we've created city-sized companies. You know, if Tata Consultancy takes it, you have vehicles and busloads, you have huge enterprises. We don't have products, we don't have intellectual property. So you take all our technology companies, it's all services based still. There are one or two isolated examples, which is well and good, but largely services, linear business, not IP driven, not patent, not products. Similarly, if you take even our pharmaceutical companies, large behemoths, very successful, globally competitive, very well run. What's the elephant in the room? Generics, right? How many times have we come up with our own molecules, our own R&D? So while that sector looks a little bleak, ironically, in certain sectors, copyrights and trademark based, we've done very well, all right, in content creation. So if you take our film industry, our music industry, which is more copyrights driven, we'll come to enforceability of copyright, which is not that rosy a story. But the key issue here is creation. But that's why I like the way he started. Create something. The protections, the monetization, and the royalties come later. But the ability to create, the ability to innovate, while has been considerably lacking in the patent space, at least in the copyright space of arts, literary works, movies, films, and now, of course, in this context, sports personalities, we've had an explosive scene. All right. Well, it's IPL season. I'm one of the few Indians not watching IPL season. Blasphemy, I know. But so when you think about this topic, IPR, firstly, there are many things. There are geographical indicators, there are trade secrets. But just imagine a visual triangle. All right. There's trademarks, there's copyrights, there's patents, and any. But the branding of the watch will be under trademark. So firstly, when you think about intellectual property, it's not rocket science.
There's a lot of buzzwords. There's a lot of multi-million-dollar cases. Like the gentleman next to me said, it's not very complex. It's simple. Let your mind split it into two. And when you think about it, also think about how India's story is a mixed bag. Successful in certain areas and not so successful in others. Now, saving the last 3.5 minutes of my speech to focus on IPR vis-a-vis sports and the business of it. IPR, there are many ways to talk about it. The positive way of saying is, it incentivizes innovation and incentivizes creation. Because why you give a limited monopoly? Whether that is a monopoly, that is an exclusivity, whether it leads to anti-competitive behavior, is a separate topic entirely. But the way it is practiced today is to give people a monopoly in the design, in the mark, in the innovation, in the invention, whatever the category of IP you fall under, to give you a monopoly of the market in which you can license. All right? Now, how does that matter to sports individuals? Okay? What's the first sports or sports person or sports incident that comes to your mind? Anyone can tell me. First one. Cricket. Okay, we'll start with that example then. So now, if you take even BCCI, is it a government institution? It will be surprised many of you to know it was registered under the Tamil Nadu Societies Registration Act way back in the 1920s. But the trademark, the name, the licensing rights, how you can even broadcast your cricket match, who has the telecast rights, all of that is under extensive royalty and copyright and broadcasting agreements. How do you broadcast it? Is it through cable? Is it through satellite? Is it through streaming? Your terms and conditions will vary significantly. So every aspect about the sports person's life, there's a monetizing aspect of it. So you take a top cricketer. The three highest in 2018 by disclosed figures was the usual names. Virat Kohli, Mahendra Singh Dhoni, as well as Hardik Pandya. On an average, their endorsements are 2 to 5 crores per deal. And these are public domain figures. Virat Kohli's companies on an average generate in excess of 100 crores only in royalty. So from the time you wear your sweatshirt, your jacket, your equipment, to the time it's telecast to the end user customer, everything is monetized. It's monetized in merchandising deals, It's monetized in sponsorship agreements on your logos, in your jerseys. It's monetized in broadcasting agreements. And I use the word monetize. It is the business. Especially when you come to trademarks. Trademarks does not foster as much innovation. Patents fosters innovation. It's a shorter shelf life, 20 years. Public domain, game over. Trademarks, on the other hand, are indefinite. So the more you build a name, so if you, and you'll see powerful trademarks beget other powerful trademarks. I'll give you an example. Everyone's shopped on Flipkart, right? Now Flipkart will get other brand ambassadors and other celebrities to further strengthen that brand. So that is how every aspect, from the time you step onto the field to even after you have retired from the sport, you're able to generate revenue streams. How am I on time?
It's about 7 minutes.
All right, so then I'll conclude. So with the positive side, so two broad themes I've brought out, all right? The distinction between different pockets of trademarks and how India's story has been successful in some and not in others. Number two, about how it is the business of monetizing revenue streams. And that's not a bad word. Making profit and making money is not a bad aspect. It's how you do it successfully and do it within the framework of law that matters. And the third, and perhaps when we have in the Q&A, we can talk about some of the challenges in it. I'll highlight some of the channels just to get your mind thinking. End of the day, the word trademark, and it rests primarily on trademark. You may have copyrights here and there regarding, the jingles, the tunes. You may have certain patents. I don't think it's that popular in India, but the way you bowl. There's some certain countries which have allowed sports patents and all of that. But what are the dark sides here? End of the day, it's tied to reputation. Everyone is very familiar with the golfer incident. You remember certain IT buildings? They had huge posters, I'm talking about 100 feet. One scandal and the brand is destroyed. The sports person's ability to endorse that brand is destroyed. So when you're doing all these endorsement deals, when you're drafting agreements for the future, everything is tied to name and reputation. And more importantly, we're all human, we're all fallible. And when you tie the brand name of a public limited institution to an individual celebrity, beware of these risks. Point number one. Point number two, ambush marketing. You'll spend hundreds of crores to get this endorsement deal, and in his private life, him or her may use a competing product. And ironically, in today's world, that will go viral, not your advertising. So beware of ambush marketing. Beware of the fallibility of the human condition, because all of these put unforeseen risks. And the third and the final thing is there's a lot of restrictive covenants and anti-competes in these type of deals. Because when you bid, you build your brand and the celebrity is tied. Imagine if he or she goes to a competitor, all of your investment and all the goodwill you've accrued gets diluted. So these are the challenges, and you're dealing with human beings. You're dealing with their performance on and off the field. You're dealing with their fallible conditions in their personal life. So all of this makes for a very challenging environment. One interview in one celebrity show makes certain big celebrities obsolete. So this is to think about it, and happy to take questions later.
Great. Thank you, Anand, for that great overview. Let's go now to Bengaluru. Mr. Nandan Kamath is here with us virtually, and sir, we'll turn it over to you for 5 to 7 minutes of opening remarks.
Welcome. I think it was a very helpful introduction. Is it reasonably clear? My voice is clear.
Sir, we're having trouble hearing you here in Chennai. I don't know if there can be an adjustment on the audio on your side, but you're coming across very faintly here.
Is this any better? Am I reasonably clear? Hello? Hello? Can you hear me? Sorry? Can you hear me clearly?
Yes, Nandan, it's a bit louder, but it's still quite faint. So whatever
okay, I'm
you
just
can.
trying to get closer to the microphone.
Yeah, that's a bit better if you're closer to the microphone. Thank you. Over to you.
Great. I'm actually just going to share my screen and talk through a brief presentation. And at any point, if you can't hear me, just let me know, and I will try and adjust the microphone. But good morning, everyone, and great opportunity to speak here on this topic, which is actually quite close to my heart. Both sport and intellectual property are subjects that I work on quite actively, and I think Anand gave a great introduction to what the issues here are. I'd like to take a slightly different tack, which is talking about both the purposes of sport and purposes of intellectual property as two separate created systems, where there are many, many common goals of both the systems, but at the same time also looking at what we seek to protect and what we seek not to protect, and from the perspective of competition and balance of different interests. So if we go back, I think Anand did a good introduction to why do we have intellectual property. It's a system of rules we create to incentivize and reward people who innovate and create, and also in the case of trademarks, like Anand said, invest and grow brands. The belief of this system, it's a social contract where we agree and discuss, believe that in the absence of these rules, there might not be certain types of economic activity that are worth investing in or putting effort into. So we provide the creators and innovators a limited monopoly, exclusivity, whatever you want to call it, to work or to exercise certain exclusive rights over the brand, so that they can in some sense figure out how to reward themselves for their creativity or innovation. So the system encourages disclosure, with the ultimate objective being human progress. So as societies, we want to move forward, and we want to reward and incentivize those individuals who are willing to put in the effort, to put in the creativity, and do special things for us as society. So we say that for a brief period of time, you can go and enjoy it yourself, or control how it is used, figure out how to monetize it, and we are gladly going to take it into the public domain once you are done with your exclusivity. When we look at sport, in fact, the only thing that changes is this left side of my slide, which is why sports. And this is again, to me, almost identical themes and objectives. So what we set up in sport is a system of rules where we're really trying to test the boundaries of human capability in different organized manners. It could be strength, it could be speed, it could be agility. In some cases, it could be how quickly you think or how quickly you move or change strategy. But in many ways, sport is another organized system which tries to incentivize and reward people who are innovative and creative with their body.
There was an interruption in the.
In some sense, to
okay,
understand as
We're
a
back.
human species what we're capable of. And in many ways, sport is that opportunity to put the best of our species out, get them to compete with each other and push each other further and further down the innovation and creativity route. And again, the objective, once again, is human progress, the belief in ourselves as a species, what we're capable of, and pushing new boundaries. And also, obviously, entertainment and keeping us occupied in times we might not be productive in the economic sense. So also keeping the social contract moving. When we look at the interplay between sports and intellectual property, there are really two aspects. There's aspects which Anand talked about, which are off-field, and I'd like to contrast them with aspects of intellectual property which are on-field. And I'll break these up into three different subsets, and I'll talk about how the law of intellectual property has interesting different interplays with each of these aspects. So as was very succinctly put, the sports business model is the off-field aspects, broadcasting, merchandising, and how people monetize sport and ensure that the organized activity carries on, and people are paid to broadcast and distribute and tell the stories to all of us. But on field, there are other interesting interplays. So there are two aspects on field. One is the equipment that athletes use, and two is the techniques that athletes use themselves. So this could be the way you do a high jump, which has evolved over 4 or 5 generations. And each new way of doing the high jump, and these are innovations that people have brought out in training, has significantly enhanced the ability to jump higher. It could be a way you play a cricket shot. I think popular in Chennai is going to be Dhoni's helicopter shot. So he may have done it first. Do you give him any exclusive rights over this? And I think looking at the interplay between these three is quite instructive and gives us very helpful ways of thinking about incentives and rewards. So very much off-field, the business model of sport is based on broadcasting and media rights, where there's an organized event and that is sold to a broadcaster. The broadcaster goes out and takes it to the world and inserts advertising in. So the broadcaster underwrites the event, makes sure that the event can be held, the players can be paid and other things, and then goes and tries to monetize this. Again, essentially based in exclusive rights of copyright and the broadcast reproduction rights. So underlying this is a strong intellectual property framework where if piracy was encouraged, there would be no incentive for the central broadcaster to take on these tasks. The other aspect is again, was something touched on briefly, was sponsorships, endorsements and merchandising. And these are all premised on the aspects of trademarks and to some extent in the US system, publicity rights, which perhaps are not as strong at an individual athlete level. But certainly the business model without exclusivity would find interesting and new challenges. So the business model of sport offline and off field is very much premised on a strong intellectual property system. And if you did not have that, you would perhaps struggle to organize events and pay professional athletes what they would expect to get paid. Going on field, there are the two, and this is the interesting distinction with respect to equipment. There are limited instances in which equipment can be patented, which, for example, it could be the way a golf club is manufactured. And what you're trying to do here is incentivize people to provide implements for human progress. So you're helping people become a better golfer with access to equipment. But all of this is premised on a couple of things. So each sport has its own equipment guidelines, and none of the equipment guidelines themselves can be patented. So there's no organized sport at the international level can have a single source of product, which is you can't have the sport only based on one product that is patented to a private company. So you have, while you have the incentives to build better products, you also have rules and limitations on the ability for new people to innovate and build other things which may not breach patents. But also you have an open access system where anyone can come and bring their own equipment so long as it's compliant with the rules of the game and the rules of equipment. When you move finally to sports techniques, these are activities and techniques that individual athletes might innovate in training and then eventually bring to competition. And here, the law is very clear and very strict that no one can patent a sports move or a technique. And there's a lot of thought that goes into this. While innovation in R&D of pharmaceuticals and other things, you could call as iterative, which is the person who invents gets this 20-year monopoly, or in someone who creates, it could be their life plus 50 or 70 years. But in sport, it is so dynamic in nature that if someone brings innovation to sport, you have the belief that it is a continuous process of improvement. It's the person who innovates may not be the best person to actually exercise or execute that methodology. So what you want is a system of rewards within sport which are not based on exclusivity or monopolies. So someone might come and bring in the new way of doing the high jump, like the Fosbury flop, but it is not going to limit other people and competitors from doing the same technique and perhaps improving the level of the jump despite not being the first to have figured out that technique. So this is an interesting interplay where sport asks intellectual property to stay off the field. And I think there's an interesting thing to take away from that, which is the human pursuit requires continuous improvement, and sport has its own internal reward system. So people play sport because they enjoy sport and get rewarded. Many of those rewards may be based in the intellectual property system, like we talked about the sports business model. But at the same time, there's a lot of amateurism in sport where people play just to play, and there's a belief that there's enough reward from the activity itself. So in some ways, sport as an organized set of rules for innovation, creativity, also asks interesting questions of the intellectual property system, which is, I think, maybe 200 years old now. Have we got it right? Would people create and innovate in the absence of intellectual property? And that's an interesting question that sport asks the broader system of intellectual property while also relying on it. But at the end of the day, both sport and intellectual property have common goals. In some cases, they have what I call divergent goals. Like I said, with intellectual property, you're giving a piece away to someone and believing that they are best in control of it. So the person who created or innovates is in the best position to figure out how to monetize it. With sport, the innovator may have a head start, but is never given on-field advantage of being able to exclude other people from exercising the same technique, which is, I think in the spirit of sport, if you took that out of day-to-day competition, you would have very, very boring sport. So you want competitive balance. You want every single person in the game to have access to the same rules and the access to the same ability and ways to use your body, which are unlimited by licenses or blockages. And the ultimate objective really, like I said, is human progress and striking the right balance between what is protected and what is not protected. And both rules of sports as well as intellectual property laws are as much about what they protect, but also as much about what is fair use, what are exceptions, and what social benefits there might be from not protecting certain uses or certain aspects and not limiting third parties from exercising certain rights with respect to those properties. So I think that ends my brief presentation.
Thank you. Thanks very much, Nandan. That was a great presentation, and we could hear you just fine. Before we turn to our third panelist, it's time for a commercial break. And I just wanted to remind you that here you are in the American Library of our American Center. We have a great collection of books. We have one of the largest American Studies collections in South Asia. I would encourage you to take membership here. Also, I'll point out just next door, we have a book sale going on through the end of May. And there are some great deals there. We've recently gone through our collection to update it, and we've been able to discard some titles. So we have book sales going on for 50 rupees up to 100 rupees, which is very reasonable. There's some very good books there. I'd encourage you to look at our book sale on your way out. Also, just a reminder for those joining us on Facebook, you're welcome to submit questions in the chat box, and we will get to those during the Q&A session. Checking in really quickly with Tanjore. Can you still hear us okay? Are you there, Tanjore? Shastra University? Yes? I see them on the screen. Okay. All right. Well, without further ado,
sorry, I think the main presentation is on mute, so we can't hear anything that's going on.
Aha. Okay. Thank you, Nandan, for
Hello.
that.
We are not able to see the rest of the speakers.
Okay, so
Now
here we are. Yeah, here we are back in Chennai, and we'll go ahead and turn it over to our third panelist, Ms. Anita Suresh. Over to you. Thank you.
Thanks for the introduction. So to begin with, I must honestly admit that I am a novice at a discussion on intellectual property and sports. So I do not have the depth of industry knowledge that Mr. Bhushan and Mr. Kamath have. So when the topic for discussion, which was IP and sports, was first presented, it piqued my curiosity to see what kind of interplay could possibly there. So I've decided to stick to something that I'm comfortable with, and I started exploring the framework of legislations and regulations which govern the issue at hand, with particular emphasis on the framework in India. So I do have a brief presentation which I will probably flip to as and when the need arises. So to start with, when I began the inquiry as to where this could come from, I went to what I think all of us would have first been inclined to go to, which is the Constitution of India. And I find that the provision for regulating or making enactments with respect to intellectual property is found in entry 49 to list 1 to the Constitution of the 7th schedule to the Constitution. And on so far as sports are concerned, it's within the domain of the state legislative assemblies under entry 33 to list 2 to the Constitution. List 2 to the 7th schedule to the Constitution. And closely following the heels of entry 33 is entry 34 with betting and gambling. So once So while this is indeed the case, and the state legislative assemblies do have the power to enact and make legislations with respect to the field of sports, you will find that there are no legislations which deal with sports or any sporting enactments. Most of the jurisprudence in India you will find come from judicial pronouncements, which mostly pertain to the structure and functioning of self-regulating sports authorities, including the question of whether BCCI is the state, or whether BCCI is the state, whether recourse can be had to against the BCCI when certain issues, including broadcasting rights, are not granted by the BCCI to other entities. There was a brief attempt to regulate sports in India with the Sports Bill of 2011, but that has since been dropped and it is not resurfaced. So far as the realm of intellectual property is concerned, I think all of us are aware of the basic parameters, basic regulatory framework which applies to intellectual property in India, which starts with your Patents Act of 1970, your trademarks legislation, and if you could please pull up the presentation. Yeah, so you have the basic framework, which comprises of your patents law, trademarks law, copyrights, and design to an extent. So when we move to patents, Mr. Bhushan did briefly mention how the industry practice when it comes to patents in India is lacking, but globally that appears to not be the case. I'm not sure if the statistics are visible, but there are thousands and lakhs of patents registered across the globe in various sports, including in golf, where over 112,000 of utility patents have been registered across the world. So patents, as all of us would be aware, are with respect to a novel invention which has industrial applications, primarily pertaining to sporting equipment or wearables, apparatus, sporting apparatus, wearables which are now picking up, and of course the various other technologies which sports persons can use in the practice of their vocation. Now, some of the intriguing patent applications and granted patents which I could come across included a cricket pitch, an improved cricket ball throwing machine, which would enable the sports persons to develop their techniques, game simulators for real life experiences when it comes to games, and so on. So this is so far as patents are concerned. Now when we move to trademarks, I think both Mr. Bhushan and Mr. Kamath have spoken in detail as to the issues that arise practically when it comes to trademarks. So I've just tried to close caption the various aspects of the sporting industry which are impacted by trademarks. You begin with the basic brands. Let's take your Nike or Adidas, or the brands which all of us are familiar with and aware of. So you have trademark protection. Under the Indian Trademarks Act, you have various classes of trademarks under which you can register your trademarks. There are over 45 categories. Sports in particular, sporting equipment and gymnastic articles and sporting is covered in classes 41 and 28. So this is where you would expect most of the trademarks to be registered in India. So apart from the basic brands and the trademark protection which is accorded to the brands, you also have protection with respect to taglines. Also taglines which enable customers and the general public to identify with brands. You also have now, with the advent of the franchise form of sporting, including the IPL, which is ongoing right now, you have a unique animal which we have to deal with in the trademark jurisprudence. So you have the Vivo IPL, which is a combination of two different brands over here. You have Vivo and you have IPL, each of which have a distinct identity of their own. So issues could arise as to how the value of these brands will be protected, because you have commentators and sports experts whom you will notice, in fact, never use IPL as a distinctive term. It's always Vivo IPL. You also have issues. So when it comes to league sports, the equivalent or the lesser known equivalent of the IPL would be the Kabaddi League, which was in fact sought to be duplicated by a different entity, and then of course the Pro Kabaddi League was indeed able to obtain interim relief against the duplicator. With this you have the issues that could come out of franchise-based sports, and then you have domain names, which are websites which are also distinctly identifiable with sporting entities, personalities, and brands. And of course, you also have the big issue of the individual and personality rights of sports persons. As Mr. Bhushan mentioned, I don't think you'll be able to get through 5 minutes of television screen space without either encountering the familiar faces of Mahendra Singh Dhoni or Virat Kohli. You could check this for yourself. Interestingly, you also have personalities registering their names as trademarks, starting with Andy Murray in 2013 post his Wimbledon victory. And you have Sachin, who's registered trademarks in categories starting from 38 to 44. Interestingly, class 45, which deals with personal and social services, has not been used to register a particular trademark. So you have sporting personalities registering trademarks of their names because of the kind of brand equity and value that's been built into their names. And of course, also this would also give rise to other issues, such as where the brand equity rests. So for instance, if you take the instance of Roger Federer's mark and the issues that have arisen between Nike and Roger Federer, while in fact Federer is quite confident that he's going to get the mark back because it was designed by him, and although it's registered in Nike's name, the fact remains that these are gray areas which could give rise to further jurisprudence. And of course, as Mr. Bhushan mentioned, the codependency quotient of the brand with the personality is quite high. Mr. Bhushan mentioned a particular golfing sports person whom you will be interested to know in the last couple of years has managed to revive his endorsements because of his performance. So it's not a static, there's no status quo when it comes to these things. The better the performance, the greater your brand equity. So that so far as trademarks are concerned, you also have copyrights which don't have too much of a jurisprudence here, excepting when it comes to broadcasting related issues. There has been a proposal to amend the mandatory broadcasting rights granted to Prasar Bharati in 2018 to include rights being granted to broadcasting not just in the conventional Doordarshan channels, but also other cable channels which are mandated to carry Doordarshan channels. But this is still just a draft in a proposal which has not yet been enacted. And one thing that I would like to add here is that while these are the conventional heads of intellectual property when it comes to sports, it's always evolving. Little do we know, I was quite surprised to learn that Zumba alone has over 50 trademarks registered in various forms and iterations. So it's an open field, and so long as there is innovation, there is always scope for protection of the, Okay, I would just conclude with that. Thanks.
Okay, thank you very much. We want to allow time for question and answers, but before that, we want to give the panelists a chance to make a quick summary, maybe based on what other panelists have said or new thoughts that you may have had before we enter into the Q&A session. This session will go until 12 o'clock, as I said, and it will include a Q&A. But first, let's hear from our panelists in the same order that they spoke. Just a quick 1-minute summary of thoughts and concluding ideas. So, Anand, we'll turn it over to you.
It was a good learning session hearing all of my co-panel members speak. So what could we summarize, which is something new and a new takeaway for the audience? I would always recommend, as lawyers and law students, many of them being law students, always wear two hats, wear the hat of the lawyer and wear the hat of the businessman. And only then you capture all risk. I hate maybe it's my background and the type of law I practice. It comes down to business interests, you know. It comes down to the business interests of either the company that you're representing or the sports person you're representing. So in intellectual property discussions, more so than any other branch of law, comes down to money. Because end of the day, that limited monopoly, whether it generates royalty, whether it generates licensing fees, it comes down to money for a fixed duration. No other brand of law zeroes in so much on the monetary aspects of it. So when you're doing this, whether you're a practicing attorney, whether you're representing corporations, whether even in social service, because end of the day, these great brands and names should actually be leveraged to raise funds and do social service. So I really like the point that you mentioned, that it was absent in that field. So whether your motives are more altruistic or more focused, more than any branch of law, when you choose IPR, wear both the hats of the businessman, zero in on the commercial interest, zero in on the time frame, and zero in where you're looking to monetize. Is it broadcasting? Then it'll be copyright. Is it in merchandising? It'll be focused on trademarks. Is it on equipment? It'll focus on patent. So have that flexibility of thought process and zero in, and I hope to interact with you guys later.
Thank you, Anand. That's excellent advice. Very good. Nandan, we'd like to hear from you in Bengaluru for your concluding thoughts.
I think he's on mute.
Can you hear me?
Yes, now we can hear you fine.
I was just saying that was an interesting perspective on figuring out the money trail and monetization, and I think that's an important perspective to continue to have. At the same time, I think it's also important to recognize that intellectual property rights are also tools of control. And it's important to set the balance right at all points of time. While you're promoting business and business interests, you're also giving enough ins to people to help to contribute to a cultural context and domains. So at the same, while intellectual property protection is important, it's equally can be a source of not just commercial control, but also control of cultural narratives. So when we set up structures and systems, it's equally important to know what to protect and what not to give exclusivity over, because there are some norms and some cultural building blocks which you certainly do not want locked up within the control of certain set of people or institutions to the exclusion of others who also have rights to interact with, remix, use, and add cultural meaning to. So I think just wanted to add that perspective.
Thank you, Nandan. That's an important perspective. Okay, back here in Chennai, let's hear concluding thoughts from Ms. Anita Suresh.
There was a very interesting balance between the two extremes over here. So to reconcile, I would perhaps think of this, that while indeed sports and the contribution that the sporting industry does make to the economy is massive. It's estimated to perhaps contribute somewhere up to 1% of the global GDP. Mr. Kamat's take as to how it should not all be locked in, and also there should be certain restraints and curtains, so to say, in making available technologies and certain aspects of sports which should not be locked up. I would say that perhaps the existing regulatory framework does address those concerns in terms of what can be patented, what can't be patented. And of course, we'd perhaps be interested in having a detailed deliberation on whether it's sufficient at this point in time to address the concerns raised by Mr. Kamath. So I feel that the existing regulatory framework does address most of the concerns in terms of contemporary issues that have arisen in the sporting industry, but whether it will suffice based on the evolution of practices in the industry as it grows, only time will tell.
Okay, thank you, Anita. Before we move to the question and answer session, I want to extend my thank you to the audience who's joining us here in Chennai, as well as the virtual audience in Tanjore. I want to thank the three speakers who've done an excellent job today. I thank my colleagues from the digital and technical team for their support of this program, including my colleague in the program section, Chitra Jaishankar, who arranged this program, and Ms. Usha Davalor, who will be moderating our question and answer session. Keeping in mind we have at least three audiences. We have an audience here in Chennai. We have a virtual audience who is following us on Facebook live. And we have also another virtual audience at Shastra University in Tanjore, which I had the pleasure of visiting last December. But using a sports metaphor, let's take the first question from the home field audience here, and then I'll turn it over to my colleague Usha Davalor to finish out the Q&A session. We'll go until about 12 o'clock, but I'll use this opportunity once again to thank you all for your time and being here today, and turn it over to Usha for Q&A, and again, look to the home field audience for the first question. Thank you very much.
Thank you. It was nice listening to the panelist. My question is regarding the counterfeiting. That is one thing which is not touched upon so far, probably. We see that counterfeiting happens at a rapid pace. Whether the penalties are sufficient in the Indian context, whether it is deterrent, is the question. So do you see any scope for that, so that counterfeiting can be sort of curtailed, if not prevented completely?
I'll go and then you could follow. So the short answer is no. The deterrence is not effective. And I'll just share for the younger students in India, the joke, especially in external countries, is we're perceived as an interim jurisdiction country, interim orders country, meaning if you don't win your interim orders, your case, you forget about it, okay, because your case takes that long to hear. So most of your jurisprudence and your cases in the practical world has been on interim orders, and interim orders will not going to get your damages and your deterrence. You're going to get injunctions again, stop releasing this or stop making this or that. And if you see, most of it has been in the field of copyright and broadcast and all of that, because both parties had the wherewithals to litigate and get the orders that are favorable. If you're talking about counterfeiting of merchandise, I mean, you know where to go in our city for that. So that has been woefully lacking. And even when you had significant business houses, production houses, media houses come in and do it, the jurisprudence has not reflected the amount of economic loss in piracy, counterfeiting, and the reputational loss associated with that. And if you ask me, have we even made baby steps to do that? I don't even think we've started those. Like, for example, if I would draw an analogy, people don't pay debts in our country, and the IBC changed that culture of corporate accountability and the ability to recover from debtors. And that was a big transformation. A lot of work needed, but we did the first steps. In IP enforcement, the joke is, if you don't get your interim orders, it's a very difficult place to be in.
We go to Mr. Kamath to answer that question.
Yeah, so I mean, by counterfeits, there's different types of counterfeits, and I mean, I imagine you're dealing with merchandise, right? Official and illegal merchandise. Was that the question specifically? Yeah, so it's an interesting point, and in fact, with respect to sport, the culture of actually going after physical merchandise is very limited. The opportunities may be a large number, but the sport business is reasonably nascent, and we have a lot of clients who deal with jerseys and other things like that, where there's an official jersey. And in fact, perspectives are very different in sport, where you're trying to build a fan base and not yet commercialize that fan base. So we've seen very interesting decisions made where people actually hold back and would rather have their jerseys worn around the city of Chennai, whether it's the legal jersey of CSK or not. You're still in the phase of fan building and fan base building. And in many cases, at certain risks, obviously, which people are aware of, may not actually assert their trademark rights to limit illegal market, if you want to call it that. So there's interesting dynamics at play. You also don't want to go after, you don't want to limit growth where you want to have your official jersey at 3,000 rupees, but you have no objection if someone is selling it for 200 rupees on the street corner as well. And across the world, there have been different ways in which people have dealt with knockoff merchandise, in particular sports merchandise. I'm not talking about other aspects where the product is the is what is being pirated. Here, these are all implements of fanhood in many ways, jerseys, merchandise, and it's not such an open and shut case as to say this is a revenue stream and I want to stop everyone else from making money off this. In fact, many sports teams would like smaller businesses to grow and be codependent on their success as well. And you want what may not be in your core area of commercialization, but in the collateral sense, you might want collateral businesses to grow, and you might want your fan base to grow in ways in which, if you exercised your exclusivity in intellectual property, may not always be the same alignment.
Yeah, I must say I kind of, I'm inclined to agree with Mr. Kamath on this. I feel that we are still a booming economy in terms of our approach to how we handle the issue. And just to add and perhaps give a practical insight to it, I don't quite know if this really happened or if it's an urban legend, but I've heard of an instance where a particular manufacturer was prosecuted for manufacturing counterfeit products of a particular brand. And the matter ended in a settlement with the defendant ending up being a contract manufacturer for the authorized brand. So I think that pretty much sums up where we stand, where the Indian market stands on the issue of counterfeiting, because instances like this are likely to happen because the quality of the product that the defendant was manufacturing was on par, if not better than the authorized brands.
Thank you, Anita. Can we go over to Shastra for the next question?
Thank you. It was a wonderful session. Myself, Professor Satish from Sastra. We have had much scholarship on issues like ambush marketing and the off-field issues which the speakers have spoken about. But I am more concerned, and my students are also concerned with regard to what Kamath sir was addressing as on-field activities. So with regard to sporting techniques and instructional videos, I would like the panelists' comments on fair use norms, especially with regard to what will constitute as instructional material. And there is a question from my student. He wishes to ask whether can there be a classification in sporting equipment as something called essential sporting equipment, because there may be improvisations and sporting equipment may be subjected to patents, but are we to give a productive ambit to essential equipment so that there is no monopoly construct that will kill the sporting joy as of such? So two parts of the question, one with regard to instructional material and fair use norms. The second part of the question is with regard to whether we need to make a classification of essential sporting equipment so that we can protect them from monopoly issues. So over to the panelists. Thank you.
Could I request Mr. Kamath to take the question first and then...
I didn't hear that. You wanted me to respond first?
Yes.
Okay.
Yes, we want.
Let me take the second question, which is with respect to the equipment, since I dealt with that briefly. There's actually an interesting interplay between equipment guidelines and intellectual property. So, for example, a few years ago, Speedo, which is a manufacturer of swimming equipment, created a fast skin suit. And it was heavily engineered, and in many ways, if you did not have that suit, you probably stood no chance of winning an Olympic medal. These suits were also priced at very, very high prices, and in fact raised a lot of questions ex post with respect to what you would call the north and south divide in sport, which is the haves and have-nots either at national levels or even within societies, of if you have a product which is so superior that it actually is an essential product in order to compete and to win, and that comes at a significant price, that actually upsets the competitive dynamics which I talked about a little bit earlier. And there's a whole set of world records that were broken at that time, which actually have been removed off the record books today, and actually these suits have been excluded from equipment guidelines. There are various different reasons for that, And as I talked about earlier, there is no sport in the world which is dependent only on a single manufacturer and a single patent equipment that is locked up by one entity. And that relates to some of the points I made earlier. I think there's only one restriction, there's only one sport, I don't know the sport well enough, it's called arena football, where the arena itself is patented. But that is the only sport in the world where there's an aspect of either the field of play or the equipment where there's only one supplier and it is patented. Otherwise, it's an open model. It's a very important and both interesting and important question that the student will ask, which is how do you keep the implements of sport free from discrimination and provide access to all? Now, you are not going to have, in some sense, an essential facilities doctrine where someone produces something and everyone has a right to it at a low cost or fee. But what you're going to have is you're going to have neutral equipment guidelines, which allow people to innovate and patent aspects. But there are some baseline aspects which are part of equipment regulations. That is even the way something has to be designed. The cricket bat has to have this shape. It cannot be more than this weight or less than this weight. It cannot be more than this curve. Those are aspects of the product that are never capable of being patented because they are generic. And the guidelines have to also encourage innovation by multiple different players, and you want people who are manufacturing this equipment to continue to innovate. You don't want there to be a static equipment where you're still playing with cricket bats from the 1960s. So while the what is a cricket bat is open source, the materials you can put in and the way in which you can engineer the wood or cure the wood, those are all aspects you want people to be creative and innovate with. And so there are some aspects where a manufacturer can get protection, and other aspects of equipment which, like the student says, are essential to the working of the sport, which we give no exclusivity over. I don't know if that answers the question adequately.
It does answer the question, sir. Thank you.
Could I ask Anita to yeah.
I would. So on the, I think there was.
I got the answer for the question. Yeah.
Okay, thank you. You want to comment on fair use? Yeah. Please.
I think the center is on mute here, so we can't hear.
No problem.
Yeah, I'm also not able to hear.
Is this audible?
Yeah.
All right. So two parts, right? Regarding monopolies being granted by patents and the ability to use or what is the level playing field that follows. And second, I think with the specific focus to instructional videos and the fair use doctrine. Barring certain instances of pharmaceuticals, from high technology to manufacturing, the field is so diverse, and the amount of cross-patenting and cross-licensing in play, the ability to do monopolies is now evaporated significantly. Like the days of AT&T being divided and all of that has diluted significantly. You take your Apple phone, display will be made by Samsung, operating system will be owned by someone else. So if you even take the foundation of the Android OS as well as iOS, it goes back to the Unix days code, source code. So the monopoly arising out of a patent granted to one company, even in high technology, is becoming increasingly obsolete, and in sports, like the gentleman earlier before me said, extremely remote. Now coming to the fair use aspect of instructional videos, there's been a number of judgments even by our very own Madras High Court, which has gradually expanded the scope of fair use to the extent of even photocopying the entire book they allowed in certain instances, which I don't think is actually perhaps fair use. So now dealing particularly with instructional videos, certain basic parameters, and it's actually almost bordering on common sense. Have you duplicated the entire video? Are you then seeking to monetize and make money off someone else's creative content? What are you using it for? That instructional video, is it for your own academy? Is it for your own personal use? What is the duration of the content you are replicating and duplicating? So all of those parameters go into what is fair use. But the evolving doctrine in India has been given a more charitable interpretations of what constitutes fair use, what constitutes public health emergencies. Generally, we have erred more on the sides of use and access rather than perhaps certain other developed economies have interpreted these matters.
Could we move to the next question? The American Center.
Should incentivize some of the
Yeah.
good questions will get some of the
Exactly. Could we request Shastra if you have the next question?
We will ask questions all day if you want. So, it's slightly off topic. My student wants to ask with regard to. Yeah, you can ask.
Good morning, sir.
Yeah, they can hear.
Hello.
Yeah, they can hear.
Yeah, good morning, sir. I'm Soumya from 8th semester BLLB Honors. My question is, in your opinion, does fantasy sports fall under the ambit of gambling?
Her specific question is with regard to gambling and sports interconnect. Yeah.
So you want me to take that?
Should we start with Anita?
I must say that this is just a personal view, and it's not tested on any jurisprudence, on any sound jurisprudence. But I would have to say that it is, to the extent that there is very little skill involved in the predictions that you make, and but I mean, what troubles me is the fact that, although this is my personal view, what troubles me is the fact that we have leading sports personalities who are endorsing these products and games. So I'm quite sure that they would not have done so without taking some legal advice. So that's something that I'll perhaps go back and look into a bit more.
We go reverse, right? Yeah. I would also ask you to open your mind beyond fantasy sports to even esports, right? And the test here is the degree of skill. And is it truly a game of chance or gambling? Some people would argue that to decide that roster takes some amount of skill to shortlist the players to see how it comes in. So I would take a more conservative viewpoint that it is not perhaps gambling, but ironically the real game and the real sport. We know this issues surrounding it. So perhaps again, we are as a mindset in a country, first thing is let's ban it. We should not. I think as a country we should be more evolved. We should be more accepting of certain things and regulate where it matters. Don't go regulate the fantasy sports. Go regulate the actual betting and all that may or may not have occurred or allegedly may have occurred in the field. So little more perspective, less banning, less regulation is always my perspective, and more living and enjoying the sport.
Yeah, so if I may interject there, so this is a very interesting and important question, and in fact, we advise many of the fantasy players. So there's actually many years of work that has gone into this, both research-wise as well as legal-wise. To answer your question in a very quick format, the answer is fantasy sports is not gambling. The law of the land under the Public Gambling Act distinguishes games of skill from games of chance. The Supreme Court precedent on this is you have to determine whether there's preponderance of skill or preponderance of chance in determining the winning outcome. And most recently in 2017, not just a general judgment, but there's a specific judgment of the Punjab and Haryana High Court in the Varun Gambar case, Varun Gambar versus Union Territory of Chandigarh, which looked at the Dream 11 case, which is one of the fantasy operators, which is also the official fantasy league of the IPR. You would have seen the logo on the grounds. Looked at that format and determined very explicitly that this is a game of skill, and it actually receives constitutional protection under 19(1)(g) as a legitimate business activity. What did it recognize? It recognized there were multiple skills involved. Fantasy sport you're choosing before a match begins. You're picking 11 players from different teams. You can't pick one team of 11 players and say, I think CSK is RCB, while that might be a possibility. You are subject to certain rules of the game, which there's strategy involved. You rely on your knowledge and information, and you have to analyze past historical records and make certain decisions based on the knowledge you already have and the information you have access to, and try and understand what in the future might happen in this match of different ways. So fantasy sport is not about picking today, is Dhoni going to score more runs or Virat Kohli. You're making multiple decisions, at least 11 decisions, including who you might want as your captain, who gets double points. It's more in the realm of trying to play something like Monopoly versus playing blackjack. So there's very clear legal precedent on this, and there's bound to be more precedent given how much this industry is growing and developing. The judgment essentially says this specific format is a game of skill, but if you change the formats, there might be ways in which this might end up looking more like chance or betting. So it's really how you form your game, how you structure the game, whether the rules are enabling a game of skill versus a game of chance. Just because you call something fantasy sport doesn't make it legal. It's how it's structured, and a lot of work goes into that structuring.
Thank you, sir. One second.
Thanks for giving me an opportunity to come over here. I'm having two queries. Two queries are there. One is whether the broadcaster can have a broadcasting right over the live event, the sports event, the live sports event. And the second one is that when we are talking about MS Dhoni, we know that in India everyone is fond of cricket. We also know about the MS Dhoni's helicopter shot, whether he can be brought under the ambit of the performance right. These are the two queries for me.
Mr. Bhushi.
Sure. I didn't understand the first question. Is the broadcaster right to the live event? What is the question per se? Because it's end of the day, it's a question of licensing and who owns the content and who is licensing to which party.
What I wanted to say that if you see the Berne Convention, if you see our own law, we say that the current event and the live event, we are not giving a broadcasting right. We are giving the broadcasting right only for the pre-recorded events. If that is the case, can the broadcaster can have a right over the live event? When it can be brought under
Why
the
do you say we are
related
not
right and the neighboring right? Right, the live event. When we are talking about the broadcasting right as a related right or a neighboring to the copyright, we have to see that whether the live event can be brought within the ambit of a copyright law. Yes.
Right.
Yes.
But I think it's a much simpler discussion that is going on right now. They have just divided multiplicity of content.
Let me tell you one more thing. If you see the European Union, there the case is there where it says that live event cannot be given a copyright.
Right.
Right. Even in India, we have the case of a Charolate case,
Right.
where also it is being stated that the live event cannot be given a copyright here.
Right.
Right. If that is the case, how we are going to relate it to the broadcasting right?
Right. No, I think we followed much simpler jurisprudence. As far as it is an event, it's a sporting event, it's a licensed event, and the holder of the sponsor of the event is given the right to license it out. And license it out to multiple platforms in multiple formats. So I don't know if you remember the earliest website, Cricinfo, had a different format of just numbers update. That was separately licensed. The actual live streaming of the event was licensed on different platforms like Hotstar and other things. So the way the Indian licensing regime works is, it's a sporting event, the sponsor event gets to license it across different formats, and when somebody like Cricinfo tried to put those on the sport updates, I believe injunctions were even granted against them until they got the license.
It was done by the Delhi High Court
Yes.
in the case ESPN.
Yes.
But there are many critics regarding this particular case.
Yeah,
by
critics,
saying that
yes.
How come the broadcasting right can be given to them when there is no copyright?
Right. No,
Right?
but
It was a big issue which was being undergone after this particular case has been decided.
Right. So in my realm, this is more theoretical than a practical question, because I don't think the entire licensing regime would collapse if such an interpretation was taken that it is a live event and therefore not falling under copyright. I would perhaps view that as a, commercial
So
viability
I
of
think what is
that.
need of the hour is that there should be change in the political decision. The jurisprudence itself has to
At
be
this
changed.
time, I will kindly put the mic down.
So, Mr. Kamath, could we ask you to address that first part of the question?
It's actually a very interesting question that has come up in a few cases. In fact, it's asking whether there's an underlying copyright in the performance itself, because sport is of a nature which is, we would like to think, not scripted. So it's not like going to a play or watching a movie where there's already creativity and thought process put into how an entire storyline is going to play out. So this has been looked at in a few cases, because sport is dynamic in nature. the participants are in fact responding to others rather than acting in concert. So there's no script that they're following. They're not actively waiting for the cue of one person to have a pre-scripted, maybe WWE or something might be slightly different. But there is a question there on whether there's underlying copyright separate from the broadcast reproduction right. This has come up in cases with respect to cricket matches and scores and other things like that, on whether the performers are actually enjoying performers' rights. And most of these debates have fallen in the realm of that they are not performances because there's no pre-thought and pre-preparation of a creative arrangement. Like, for example, dance. There's a dance arrangement that has been established before and the person is exercising that design. While sport, the way someone hits a tennis ball or shuttlecock is technique, but what they're actually doing with their bodies are performances of a sort that in general performers' rights may not generally apply to. So this has come up in a few both High Court and Supreme Court cases, and it's a very interesting question, perhaps left at the theoretical level at this point. It's not really come home to roost at the commercial. But I think really broadcasting rights relies on the broadcast reproduction right, like Mr. Bhushan mentioned.
Just my 2 cents on that question, ma'am. On the issue of whether Dhoni's shot itself can have some distinctive intellectual property vested in it, I thought you might be interested in knowing that the method of playing a sport is expressly excluded from patents. So whether it will fall within a performance right is a distinct question that we can examine, but going by how the patent jurisprudence is evolving, perhaps it may not be. So then, I mean, that would effectively have the consequence of no other player being able to use that style. And on the issue of whether the live broadcast itself has copyright vested in it, I did come across some Chinese decisions which seem to have deliberated on this issue in detail and have given findings. Perhaps we can supplement it with our Indian jurisprudence to see where this can go.
Your thoughts?
I thought we already did.
We are going to the social media question. This is from Harish Malpani from the NMIMS School of Law, Mumbai. His question is, if a situation arises where an individual sportsperson is endorsing a particular brand, which is a direct competitor of a brand which is sponsor of the sports competition, whether the sportsperson will have to drop the endorsing the brand in that particular competition.
So this is, even though the question sounded complex, it's actually a very simple question. Competing brands in the arena and how you're accommodating all of that. The jersey is a brand, whereas the stadium sponsor is different. This is all done by private contract. It's all private contract, and believe me, the level of sophistication that goes on and the amount of exclusionary terms. Meaning, like if I am, so if it's what Vivo IPL, I'll be hard. The amount of ambush advertising that goes on between the commercial breaks will give you an idea of. So all these are, so it's all contractually done. And end of the day, it all depends on leverage, all right? Because the weakest cog in this link, unless you become a mega cricketer, the weakest cog in the link is actually the sports person. Because the sports person will sign many of these contracts and they are wrapped up many on at the early stages of their career, and the renewal clauses and everything is all loaded in larger parts of the corporate. So your restrictive covenants, your non-competes, your cooling off periods for who you may advertise for, even after as an endorser or a sponsor I terminate your contract, is all woefully loaded in favor of the corporate house. And the corporate houses, end of the day, make the deals as to who gets the maximum visibility in this space. But what is the saving grace is, previously the IPL, in IPR and sports was purely a cricketing discussion. But if you see 2018, of the top 10 high endorsement deals, nearly 4 were non-cricket sportspersons. And sometimes first names, whether it was Sindhu, whether it was Saina Nehwal, of course, older name, or Hima Biswas in athletics. And there was a shooter as well. So 4 or 5 names, and they negotiated fairly successful deals which allowed cross-licensing, which allowed representation even in other areas rather than exclusivity and tied down to one sponsor. So it comes down to contract, it comes down to leverage, and it comes down to how cleverly you have negotiated cooling off periods and your non-compete terms.
Just to add to Mr. Bhushan, I would draw Harish's attention to one of the landmark decisions of the Supreme Court in Zahir Khan's case, where they clearly laid down the yardsticks as to when a particular brand can seek to tie in a sports person with the brand indefinitely, and it was of course held to be untenable. And curiously enough, on the issue of private contracts between the players and the teams or the sponsorships, I think, as Mr. Bhushan said, it is a matter that is to be addressed in the negotiations between the player and the franchise or the team. Fun fact would perhaps be, if you notice, Hashim Amla's jersey will never have any alcohol endorsements, which might appear in his teammates' jersey. So I do believe that it's a matter that needs to be negotiated with by the player.
Mr. Kamath, with regard to the second question,
which is the branding of players versus. So this is actually the subject of, in most cases, tournaments have their own regulations. There's a whole waterfall of rights between the tournament sponsors, the team sponsors, and then individual sponsors. So there's always a balance to be had among and between them. And for example, the Olympics has very strict guidelines on even athletes promoting their personal sponsors, whether they are competitors or not, during the Olympic blackout period. Cricket is much more in favor of athletes being able to exercise their commercial rights during that period, even if it's a competitor. So what you'll have are sponsorship guidelines as well as agreements. So it's a regulatory structure of the top body like the ICC or the International Olympic Committee. And then each team is obliged to have contracts with their players. The teams have contracts with the governing body, and by sport by sport, there's significant differences. In general, the tools of the trade, which is the equipment with which you play with, is left to the athlete's discretion. So even if a manufacturer of cricket bats becomes a sponsor of the league, you will not be able to prohibit players from using their own cricket bats which have logos of competitors. On the other hand, there might be some other categories which you might prohibit a team from having the same sponsor as the tournament, and in very few limited instances, like I said, in the Olympics, a complete ban on commercial activity during the Olympic period, and in some limited instances, for example, during the World Cup of cricket, the players are not restricted in any category, but they are restricted in doing any advertising in the same color clothing as their national team gear. So, for example, during the World Cup, which is upcoming in the next few weeks, you will see a lot of Indian cricketers advertising different brands, but they are prohibited from doing it in the blue jersey and blue pants to make it seem like it's the Indian team player who is sponsoring it and to try and build association with the Indian team. But otherwise, there's complete freedom in being able to sponsor or endorse any other brand which may even compete with the official brands of the tournament. So it varies from sport to sport.
It's very, I'm immensely satisfied hearing to my students, very elaborate things. If you understand basically the difference between sports per se and promotion of sports, this is one thing. And amateur sports and professional sports, that is where the questions are revolving around. So if it is a professional sports and promotion of sports, lot of business activities, we should have two bats. But when it comes to per se sports, I agree fully with the Nandan Kamath that we should have some basic ethics or whatever it is. And with reference to the per se sports, we were discussing only about patents and also copyrights and to some extent trademarks. What is the designs? What is the role of designs in these things? Because I remember both of them used to have a heavy bat. Because if I can do my own designs of bat, whatever it is, what is any law is there? This just to get enlightened. I'll be happy to have. What is the role of designs? We have so far we have our discussion revolving around patents, copyrights, and designs, promotional activities or promotion of the whatever it is, all the patent things. In what way are we are talking about the ball techniques, whatever it is, ball bowling machines, etc. So, about anywhere we have been discussed the designs for that reason. Because I don't come across anything in the thing. That is why I wanted to know.
That's a very, very interesting question, sir. And for, perhaps I do have. I was reading one article which did deal with the various aspects of it, which included designs. But as you rightly pointed out, the focus is more on patents, trademarks, and copyrights, and primarily it's just trademarks for most part. Designs, I don't know if any of the designs have been registered. And to take it from your illustration of Botham's heavy bat, I think the mongoose became very famous when Hayden started whacking bowlers out of the stadium in the IPL version of it. But this is something that's very interesting.
No, honestly, sir, I have not had experience. Most of the thing has been, actually 80% of our work is revolved only around trademark and copyright, because that is so regarding design patterns, the ability to innovate also, from my experience, what is the tournament rules, regulations that prescribes weight, circumference, the type of materials, the frequency of swapping out, everything was highly regulated by tournament rules. So I personally not come across any type of design filings there.
Mr. Kamath, would you like to address that question from Dr. David Ambrose, who is the IP chair at University of Madras?
So this is with respect to designs. So this, I think Mr. Bhushan's explained it well. This is an issue that comes up from time to time, especially with the design of equipment when someone tries to build something slightly different. So if you try and innovate, you can't get a design copyright or design registration over the most generic version. So something that just explicitly follows the equipment guidelines, because then you're actually limiting other people from building it. But on the other hand, if you use some new material in a product and it ends up not having a functional element, but you're designing something to work better. So for example, we've seen people who have tried to build new types of batting packs. They meet the regulations, but they do something which makes them significantly, in the shape that they've been designed, they make them easier to run. That could be the subject of a design patent, design registration. So there is certainly room for some level of innovation, but it's limited, like Mr. Bhushan says, by equipment regulations. So something that strictly follows the equipment regulations is not going to get you a design exclusivity.
So it's time for us to wrap up, and I'd really like to thank our panelists who have been extremely good and excellent in providing very comprehensive and holistic perspectives. And thanks to our audience from Tanjore and Chennai, and all the participants who have been watching this on Facebook Live. I'm sure you all will agree it was very comprehensive. They addressed from the constitution perspective to the cultural perspectives. It was a very engaging discussion, providing us inputs both on theoretical and practical areas. Thank you to all, and we welcome you to come and engage with us in more such events. Thank you.